Okay, thanks a lot. Hopefully, because of 4 hour session, it's important we don't have those, like tea breaks. I'll do another break in probably an hour. So there's only so much that we can absorb at any point in time. So we're getting down to the nitty gritty now. So we've got Max and Samantha, 37 years old. Looks pretty basic. Now, there's obviously for all of you, all of you probably going, oh my gosh, there's so many things in here that we've got to look at. And I'll look at some of the ancillary issues. But the first point is that, again, going back to Tony's issue, which is crucial, is we want to set amount of data capture. So I've got like Max and Samantha Smith data capture. And what I'm going to do is I'm going to show you what that looks like. So up on my screen. And then I'm going to show you where to find it. So today is very hands-on practical. So if the client comes in and Max and Samantha's, they want to get a will and an EPOA from you, I generally just don't do a will. I think it's important actually do both at the same time. So the best system that I can get, obviously Tim's going to come in and change GPS. You guys have got some great tools there as well. But what I've done is, if you have a look at the Lightyear Docs site, and we can see I've actually got that there. I'll come up a bit later on. So with the Lightyear Docs site, and we're actually going to be doing this change it. Anyway, it doesn't matter. You can go to the Strategy Center there, and you'll see inside the Strategy Center, there's a lot of stuff there. All the webinar videos. So if there's an issue around investment strategies or how to do wills or, all of the Tony stuff said. So the stuff we've done today, every little bit of it's got, a good hour webinar around it. So that's your learning point. What I'm doing now is we're starting to build little toolkits. These are the ones that I like. For example, Grant's email copy done for you. So what I would suggest is after this, once you get on top and, you do the wills for yourself and you're really comfortable with it, where you're sitting. Look, I've got here an email headline. So obviously you don't put that in, but you simply just copy and paste all of this. So this is just straight copy and paste material, send it off to the client. You've got your will and data capture there, which I will, David, I'll probably put in common parties as an update for there. So I haven't done that for this system, but we've got our EPOA and will data capture. So you add that as an attachment and send it off to the client. They'll come back and I'll take you through the will and data capture. So this is the one you can see on screen that we sent off to Max and Samantha Smith. They've come back for us. So enduring power of attorney will. The following enduring power of attorney and will interview captures details around who will be looking after your affairs in the event of your incapacity or demise. It also goes into whether you want to leave any specific gifts to anyone, and finally, who and what percentage of the estate you would like to leave to your primary beneficiary. Also, for completeness, if they are not alive, what is to happen to their share and so on. If you have any questions, please don't hesitate to contact us. So again, this is your document, so you can put in all your details, put your logo in, so on and so forth. So the first one, this is succession. Who's to be your enduring power of attorney and executor? Put their names and addresses in the box below. This may be held jointly by one or more persons. If you want different persons for the roles, write in the box below the name of those persons. But for simplicity and safety, it's best to have one person or persons being your power of attorney and executor. So obviously, they've come back and said, well, Sam is going to be Max's and Max is going to be Sam's. Now, if none of your EPOs or executors can fill their duties because of sickness, incapacity, or death, now remember, a lot of people, in fact, turn down the role of being an executor. So who's to be your second in line EPOA executor? One of the reasons that you don't need to get your executor to sign your will at law, but we get it to do it, is so that the executor has been given a heads up that they're acting as executor and they're consenting as such. So you don't want to be going down the track and building this brilliant will with an executor and effectively find out that they don't want to act as executor. Then you have to, the whole process gets turned on its head. So for Samantha, her executor is going to be Francine Brown. And for Max, it's John Smith. We're going to pull John in a little bit later on to have a look at the moat. So this is just a basic LYD will and EPOA. So we're not in the moat yet. So I just want to show you how it's done. Now, if none of your first or second line EPOAs or executors can fill their dues because of sickness, who's going to be the next one? So what we've done is we've just gone, they've gone not applicable. But that's something that you'd question. So look, you know, what happens if all these guys are around, who's the next one in? And during powers of attorney, your EPOA will look after your personal, financial, and if you have SMSF, can act as a trustee of the fund. You can give them unfettered control or provide limits, such as ensure that any healthcare is to a higher standard. So what I've got here is, you know, make sure my health and wealth is looked after for my family, ensure we receive advice from our accountant, Nathan Blunt of Blunt's Accountants in DY. So that's okay. So we've got that. Now, wills, specific gifts. Now, this is important. After appointing a chain of executors to manage your estate, the next step is to guide your executor with your desire to make a specific gift to a spouse, child, grandchild, or other person. Once this is done and the gifts are made, anything left over forms the remaining estate, which may be passed in its entirety to a spouse or children individually or to be shared. Importantly, specific gifts rank higher in importance than the remaining estate. So spend time on the specific, which is absolutely crucial. So the first step is then to look after specific gifts. Now, do you want to make any specific gifts to any person, such as my investment property at 5 Smith Street, Collingwood, Vic, is to go equally to my eldest daughter, Jane. Or should actually be Jane and someone else. Or my sister, Joni Smith, is to receive $100,000. All of my estate is to go to my wife, Janelle. We did one recently at Abbott Mourly, and the testator paid an amount of $20,000 to each of his grandchildren that were alive at the time. So he did make each of those ones as a common party, and then also cover the thing. Feel free to make as many bequests as you want, or as many gifts. So specific gifts, this provides your executor with the authority to transfer property, share, jewellery, cash, or a percentage of all your assets after any specific bequest to a certain person. Please be as specific as possible, so on and so forth. Please note that this area is the area to gift digital assets, such as social media databases and cryptocurrencies, such as Bitcoin. So when we go down to specific gift, we've got, we haven't given any specific gifts there, but Max does have 3 Bitcoin there, and it's 16,186, and that's obviously going to be paid to his spouse, Sam. So what we've done is we've done our specific gifts. Now what we're doing is we're moving into the role. So in fact, Mary, you've got a really good question there. We're about to go into the remainder of the estate. So you'll find, Mary, that in our, I think it's in our will with testamentary trust, but I'll have a look at it in our normal will, you can appoint a specific executor for your digital assets. So you're obviously going to need all the passwords, etc. And we've encompassed that inside the will there, but good question. So if there are any assets or monies left over after paying all expense of the estate, so when I come down to the protector, if there's any loan amounts outstanding, then effectively they're going to get caught up and they'll be paid before the remainder. So it goes loans, taxes, funeral expenses, any other expenses, and then what transpires, it then goes to specific gifts, and then it goes down to the remainder of the estate. Does that make sense? So loans, taxes, stamp duty, other expenses, funeral expenses. Then the next one, it goes down to specific gifts. Then what's left over is the remainder of the estate. So what we've got here is the main beneficiary. Obviously, Max is going to Sam, Sam's going to go to Max, each other 100% of their superannuation. Now, they haven't got an SMSF here, so all the discussion that we had before was superfluous, because if you're in Australian super, you don't have many chances whatsoever. What you have to do is you can just pay it directly out to each other or to the estate. Now, one of the benefits of paying it to the estate is obviously we could do to the could do a testamentary trust. Now, if the main beneficiary or beneficiaries are not alive, who's to get their benefits? So rather than building testamentary trust, this is a really simple way So, for example, Max dies, Sam dies in the same accident. So we've got Janine and Kathy needing to be looked after. Then what we've done is you've got these 4 choices, and you'll see this when we go through. So these are 4 buttons. You click them on the system, as Tony said. The legal's already done for you. You're just checking which of the options, and the options are actually chosen by the client. So their bloodline children, which may be held on trust subject to the executive's discretion on the advice of the advisor to the estate, which is our mate Blunt. Any surviving main, they don't do that, so they've chosen this. I could have done an X, but it didn't work out really well. Is there going to be a secondary beneficiary? So, for example, if Sam's not alive, it could have gone to the brother or the children if they're over 18. But what we've done is we've chosen, because they're so young, to go into the estate. And again, secondary beneficiary doesn't apply. Funeral wishes, both to be buried at Rookwood Cemetery and my grandparents' funeral plot. Child and pet guardianship. Now, this is important. So the girls will be looked after by Sam's sister, Francine. She and my brother, Chris, are to be the joint trustees of the trust established for the girls, and any money is to be used to provide the best possible school care, and they can receive income from age 18 and capital from age 25. Pet guardianship, which we've included. So in the event that they all die, then Tinkles the cat's going to go to Francine, and that's the end of the interview. So that is the data capture then for your client. So I'll just put that one to the side there. And then what I'm going to do is open up, oops, I'll just get that little document up. So I'll just put that to the side so I can copy and paste. You'll have a look, and I'll have a chat with Mick very shortly, which is important. Been in our new Lightyear Docs 2, we're going to be in a position of being able to have a scenario whereby you'll be able to send out the data capture, and then it'll pre-fill the interview directly into the system. So that's down the track. Now, what I did is just to save ourselves time. So you can see here, I'm up just in Lightyear Docs Home. I'd go through, and if this was me, I would drop down to the estate planning option. So I have a look at the list, document categories. I'll go down the estate planning option, and then I would choose this one, the LYD will and enduring power of attorney. So that's the EPOA and will automation. So you'll see there. So that's for $198. So what I'm going to do is, I'm not going to do that because I pre-filled one. I feel like one of those, you know, the chefs, you know, I've already done this to cut some time. So I'm just going to go into my document storage, which I've done here. I don't know why it was logged out there. So let me just have a look. Okay. Oh, actually, I logged myself out, silly me. Okay, so I'll go down to my document storage. So because I've logged in, this is my dashboard. So this is what you guys should see. Strategy Center, love that. So I'm going to go into not in progress, my completed documents. And let me go through. In fact, I might go just straight into the, rather than search, I'll go straight into the document storage, go into my vault. You can see October Strategy Day. We've got 2, we've got the Moat coming up, and then we've got Max and Sam Smith wills. You can see here, I could download it, I could delete it, or you can see I've worked on it. That little button shows when everyone has touched that document. So it's absolutely crucial in terms of compliance. So a little rocket ship. So let's relaunch and see what we've got and build it. Okay, so this is our EPOA and will automation. So I'll put the name down there, Max and Sam Smith wills. For wills, etc., I definitely put the Abbott Mourly logo on there. You can see the default Abbott Mourly 001 or AM001. So these are the common parties that we're talking about. So we've got Max Smith, Samantha Smith, Janine Smith, and also Kathy Smith. So a couple of the ones that I'm going to have to pick up from the data capture. So have a look at the data capture, and I can see that we've got, which is going to be important, going up to the executor. So each other. So I've got both of those caught. I've got the kids in there as well. Now I'm going to have to add another. So I just go down here, add another, and then I'm going to put in here Francine Brown. So obviously, hopefully your clients have got that. You can see when we do overseas. So it's not an overseas address to make it too hard otherwise. So to 12 Brown Street, Manly, New South Wales, 2000. So that's the sister. So I go back to the data capture, so that's okay. And then for Max, we've got John Smith. So we're going to add another there. And then we've got individual there. We've got John Smith. Also Smith. Can't even do it myself, silly sausage. And then we've got, is this an overseas address? No. And he lives at Smith Street, Sydney, New South Wales, 2000. So we've got that, and have a look at, I'll go down the data capture. Is there anyone else that we need to put in there? Probably we've got Nathan Blunt, so I might even put him in there as well. So Nathan Blunt, overseas address, no. So put 5 Street. That was, I think, DY. Not sure what that is, postcode, but anyway, I'm sure some of you will probably tell me. 2098 I'll put in. Okay, so I've done all the common parties. So that's the crucial one for us. So once I've done that, now let's go into the stuff. So that's the crucial one. So if you get those common parties, to do thing. So I've got a couple of questions here. What if specific gifts don't exist at the time of death? Then obviously what will happen, Sharon, is you're quite right. They may be created. It's probably not at the time of death. It's actually at the time that the executor is going to distribute the estate. So that'll be the question. Phil, can we run the interview in a Zoom meeting? I've got a session which is sitting in a strategy center of how I do this. So I don't even do data captures. What I do is a session here where I have a Zoom with a client, and then I'll be on the Zoom with the client. I don't share the screen. I just simply say to the client, what's your address, what's your brother's address, all the common parties. And then I just simply go through and ask them the questions, which is the same as a data capture. You'll find that is the most effective way because you set the appointment up and it's done there for you as well. Suggested text standard paragraphs, you'll see when we go down, that'll be coming in a little bit later on, Steve, as well, which is important. But again, if you need something like that, again, just come back to us support and we can take it there as well. So Sharon, if they don't exist, would that leave the intention to split the value? Again, it's going to be an issue for the executor, but I'm sure you've probably got, if you've got something specific in mind, Sharon, please let me know. That'd be great. So if you don't have anyone that can be an executor, Brett, that's a really good, what do you do? In fact, this was raised just recently. You can use a friend, which is important. An accountant or a lawyer, the local lawyer. The only problem that you have there, Brett, and I'm talking professionally speaking, is I've seen too many cases where accountants or a planner or a lawyer have been involved in the executorship, then makes it very difficult for them to charge reasonable fees because all the beneficiaries are going to have a go at them, if that makes sense. Whereas if you put someone in there who's executor, you then control the administration of the estate. So then what happens from that perspective is you then get those fees. So my preference is I wouldn't be an exec. I'd be an executor of any of my family members, but I generally wouldn't be for a client if I was also going to charge fees for it. So just be careful. I've seen Supreme Court cases on that. So we've got this. I'm going to save the answers because I've been flopping around a little bit later on. For those of you, we're having problems with Edge at the moment, but we've got Google Chrome now works. As you can see, I've got Chrome up there. and then there's just a couple of little workarounds you need to do. It's because these damn browsers keep on changing their cookies. So let's go down to the documents. So we know they're in New South Wales. So I'm going to do a New South Wales EPOA. Do you want to complete a basic will? Obviously, yes. Now, this is important because you're going to get a letter of advice, which is included in the kit from Abbott and Mourly, that says that you, the advisor to the testator, has not prepared this, is not providing legal service, and that effectively you are simply providing from the data capture. That would also include Phil if you're doing it directly. So you'd always put in there yes, and then we'll go there. So select the accounting firm. We haven't got one there, so we'll just put Blunts Accounting DY. So I put that in. I then go down to the enduring power of attorney. So that effectively will cover me there. So I've got it pretty. So I've got a question. I've got to advise it if, as accountant, I am to be the executor, it's critical that you don't be witness to the will. I'd have to check up on Tony with that one, but that's quite interesting. Also got a question there. What does the Bitcoin price go up significantly? That's not a real issue because if you've given a specific gift, whatever it goes up to, that's what they get. Obviously, if you don't put it as a specific gift and it goes in the estate, then it forms part of the residual estate. But really good question on that one. Is this interview something a non-lawyer can do? Absolutely, because as you'll see, all the legal guts of it, as Tony said, is embedded in the document. You can't, from what I've done so far, you haven't done anything. There is no legal drafting at all. All you're doing is getting from the data capture, or as Phil said, essentially you've got the position basically in there, and then you're off and running from there. The fee in terms of what you're to be paid for, that's a really good question. That you're going to be paid could be stated in the will as executors. So that's not, you'll find that anyway, there is a section in there, the executors are to be paid remuneration for the work they do. The only one is I've seen so many complaints where beneficiaries take them to court, and that's the last thing you want. But again, if you're something specific, it's fine. So let's go down and have a look. So all I do now is, this is where it starts to get simple because of the common parties. So I wouldn't put in the date of the appointment of the attorney because you don't know when it's going to be signed. So let's go down. I'm going to do one for Max Smith. So you can see how it's all pre-filled in from there. The attorney, remember I've got it from the thing. So I've got the attorney is going to be Samantha Smith. The replacement attorney, yes. So I'm looking at Max at the moment. Is there a joint? No. So who's the party? Remember that was going to be John Smith, and they didn't want to go a next one down. Does that make sense? So all I'm doing is pressing buttons. So you can actually see the question. I'm not doing anything really. Okay, the power of attorney. So let's go through here. This is really crucial. So there's a whole lot going on. So our power of attorney is unlike anything that you've seen before. We've rolled a lot of stuff in there. So the first one is that embedded in the enduring power of attorney, which is not the case here, you can act as a replacement trustee or replacement director while the enduring power of attorney is valid. Now here they don't have a self-managed super fund, so I'm not going to tick that. If I tick that, then that comes up in the power of attorney. Do anything on behalf of the principal can lawfully be done by an attorney? Absolutely. Act as a successor director where the principal is a director and no longer able or willing to act as director through incapacity, death, or their own choosing. So that's successor director. That's better than alternate directors, and I've done a whole session on that. But he's not a director at all in this stage, so I'm not going to tick that. This is just a really basic will. So when will the power of attorney commence? So you've got three options there. I'm just going to do it upon signing the document. Do you want to revoke previous appointment of attorneys? Absolutely. Now, in New South Wales only, listen, I'm going to say again, in New South Wales only, Section 19 of the Powers of Attorney Act requires the solicitor sign off the EPOA. So you can either take this EPOA and go to your local solicitor, but they probably won't sign off, because what they'll do is what has to happen is the solicitor has to explain all the various issues. You're better off just doing a Zoom with Tony, and he charges $150 for it. If you go to your local solicitor, you could try, but they're probably going to want to do their own EPOA. And unfortunately, their own EPOA won't cover all of these other things that we've got, successor director. So let's say we're going to go Tony, and then we've got, I authorise my attorney to give reasonable gifts as provided there. So yeah, that's okay. They can give gifts. I authorise my attorney to confer benefits on the attorney to meet their reasonable living and medical expenses. So do you want to go down that track? So this is, again, that's probably a good reason, Phil, to actually do it on there, because a data capture, you can only put so much in, whereas here I can actually say, well, do you want to make sure you can give gifts? Do you want to confer benefits? No. Authorise my attorney to confer benefits on such a date. No, so I'm going to do that. And then you can put additional powers of the attorney. And remember, we had that one here. So I'm just going to copy and paste that. And so that's the additional powers of the attorney, and there's nothing else from that. Okay, so that's my power of attorney done. Now I'm going down into the will, if that makes sense. So I'm dropping down into the will, and what will go from there is we've got, first off, obviously, it's Max Smith. And now the professional advisor, we've got Nathan Blunt. The only problem is if you do Blunt's accountants, you've got to be careful if he's still there. It might just be better to put Blunt's accountants. Okay, the executor, remember, is going to follow the same. So it's going to be Sam. So that's okay. And that is the spouse. Successor executor is obviously John Smith. And we don't have to worry about relationship there. Second successor, no, not going to do that one, so that's fine. So you can see it's pretty easy. Specific gifts, I can jump down there. There is no specific gifts here, so I don't have to worry about that. So then we go down to principal beneficiary. That is going to be Samantha Smith. I hope I'm not going too fast for all of you. This is why it's worthwhile doing, as Tim said, to go and do your own one. So 100% of my estate is okay. Now then we'll choose, they've chosen the bloodline children. So that if Max is dead, Sam's dead, then we've got to make a choice here. So here, if they've got young children, it's going to be their bloodline children. So the secondary beneficiary, is there a secondary beneficiary? No, because it's all going to go to the bloodline. I mean, we could put in there, no, it would be the case. So specific gifts we haven't got. Digital assets, yes. So we've got that. Would you like to appoint a separate digital executive to manage these digital assets upon death? So let's go yes, and that'll come down a little bit later on. So then we've got digital asset. Who's going to be your separate one? So let's make this John Smith. So that's the father is going to be the digital, because we'll say, then details of digital asset. So you can put in there Bitcoin, and I forget where to access. So where did I have the Bitcoin? Just down, sorry about that. I forget the exchange, BTC exchange. So that's pretty famous. So BTC exchange, and they actually do it in Australian dollars as well. Username and password. Let's just put Max Man, and you can put the password in there. So I'd have, guys, don't take this as verbatim. I have no idea. I don't have any Bitcoin. And then you can put additional there. And then you could add another asset if you wanted to, for example, put in there your database or your whatever. So you can see we have thought about it. And look, this is the only will you see in Australia that has this. But if there's none, then don't worry about it. Child guardianship is a nomination, yes. So select the child or children. So this is why I've got a bit of a typo there, so I'll need to fix that one up. So we've got the two children, Janine and also Kathy Smith. And Kathy Smith. Select the guardian is going to go to Francine. select a succeeding guardian. So if Francine's not there, then I would go to John. So if they haven't included that, then what you do there is you just ask them again. So this is, again, I'd probably go back to Phil's thing. It's much better to do it online because you can ask them directly there. Second, succeeding, I'll just put NA there, so not applicable. Then we go down to parent guardianship. Yes. Select the party. It's going to go to Francine. It's a cat, and the name is Tinkles. And we'll just put Tinkles pet insurance. Insurance for 5 years. So that's paying the pet insurance. And then we go down. The final one is the funeral wishes. And then, yes, we want to do the funeral wishes. And then all I do is just go back to my data capture. And it's to be at Rookwood, I think, both. Control C. Okay, to be buried. Okay, save those answers. So effectively what I've done there is I've gone down the track and I've done the will and the EPOA. Now, what I can do here is I'm not going to do it at the moment just for saving of time, but I could go yes, and then that would, as you can see there, would throw up a whole set of documents for Sam. So I do an EPOA, you go through the whole thing again, and then you get that as well. So I'm not going to do that just to save time, but obviously you can see it would, wouldn't take that long anyway. So I just get to there, and then I'm going to finish that. Now the thing about it is this comes out, goes in draft. What we've done is, and I think when we had a look at it last year, Michael Goot was saying, why can't we just have an open-ended, so there's no time limit in terms of accessing the documents which we have. So once you do this, the beauty about our system, quite apart from it's pretty inexpensive, as you would see. I've only done 2 docs, but remember I could have done another 2 docs there. What it means there from that perspective, and what I'll do is I'll send this document out to you as part of the package. What happens from that perspective is that you send this out in the draft. If it needs to be updated or changed, then what we do is we then go back and you can go back and make as many changes as you want going down the track. So, for example, even if they go on in 5 years' time, we find that Max and Sam have split up, then we can go back in and create a brand new will and testament for both Max and also Sam, because you've still got that information there. So it comes out as in a PDF, which is another reason why it's pretty important that by doing this effectively, all you've done is just the data capture, all the guts, you can't go in and change. If you converted the PDF into a Word document, that's where you start to void that power that Tony talked about, not being legal advice or drafting. So here's an important one. The attached will and EPO is based on the data capture form given to you by Bloods Accounting DY. It uses current legal precedents provided by our legal firm, Abbott Mourly, to look after you in the following manner. Who and how to choose as your attorney, so that's your EPOA and your will. It is important that you read the following, as the legal nature extends beyond the data capture and administrative processing completed by Blunt's Accountants DY, who are not solicitors, do not hold themselves out as such. However, your advisors are expert in estate planning matters, including taxation, asset protection, succession, and ensuring where required that the estate is limited to the deceased bloodline or lineage. So what documents are attached? You've got your enduring power of attorney, and then you've got your will there as well. Now, importantly, very important, wills can be challenged in the Supreme Court by any eligible person, including children, grandchildren, ex-spouses, and others who feel they've been left out or not adequately provided for. This can delay the transfer of assets, and with court costs, eating the estate and gifts. So if any of the following have occurred or likely occur, please contact Blunt's Accounting immediately, because we will need to provide you with a more protective, tailored will. Are you getting married in the near future? Are you separated but not yet divorced? Do you have an ex-spouse? Do you wish to exclude any close family members? Have any of your kids got mental or physical problems, marital bankruptcy, or a big spender? Do you own a business or own shares in a family company? So we need to do a successor. Do any of your beneficiaries live overseas? So if none of these apply, then you do that. And then this is a general letter of execution for the EPOA. And then we go down into the enduring power of attorney. So again, this is for New South Wales. We go down there. This is straight off their I think it's I forget who the public legal provider from New South Wales government. So IMAX Smith appoints Samantha Smith. Now remember, there is no SMSF or directorships. If you tick those extra boxes would have come up here. Nomination of a substitute attorney. We've ticked those boxes. Remember, authorised power to give reasonable gifts. Make sure my health and wealth is looked after for my family, ensure. So you're putting in these little ones there. And then it's signed by the principal. This is where Tony comes in and signs it there. And I'll get Tony on in a second to talk about that. Samantha Sis signs, and then John Smith, who's the second one as well. So actually they're together. So then we go down to the last will and testament, which you'll see here. Then I'll look at some questions. So this was made by me. Now we don't know. So when they do come in, you just jump into the back into your vault, pull up the Smith will and EPOA, and then you'll just go through and put in the date and get them to sign. And you'll see when it comes out, they need to sign each and every page. So I hereby revoke all permanent wills. I appoint my spouse Samantha as my executor, so on and so forth. So it's all the stuff we did before. Provision of advice. It's my strong wish that my executor obtains and considers advice from advisors in making business. Any advice will be properly remunerated and ongoing for my estate. So that appointment puts you right in the box seat there. Initial administration, remember we went through this. So convert any estate, pay out any debts, taxes, contributions, funeral, other expenses, etc. loan. And then the beneficiaries of the estate, obviously, is spouse Samantha Smith. So she gets 100%. If Samantha Smith is not alive, their share of the estate are passed to their bloodline children, may be held on trust subject to the executor's discretion on the advice of the advisor to my estate. So we've put it in there. Now, if there's no one around, then the executor is going to put it into the DNA. So that's, for example, if there's no one around and John steps in, then effectively you can pass it out. So the child guardianship, we've got Francine, and then we've got John, and then we've got all the guardianship, pet guardianship, Tinkles, funeral, buried at Rookwood Cemetery, general powers of the executor, specific powers, cell call in. I think if I've got here, employ professional advisors, here including legal practitioners, accountants who assist in administration, including a firm in which the executor or trustee is associated by virtue of being a partner. So we have covered that one in there. So essentially, that's again more powers. You sign each page. You've got a special schedule there for the digital assets. And then obviously you don't put all the details there we've got the details there as well. And then signed by the testator, signed by the digital executor. And then we're off and running from that one. So I'll just take some questions and then I'll hand over to Tony. So Brad Smith, in this day and age, when passwords are programmed to be changed regularly, how do we manage these changes when they occur? We're putting a password in the will that may no longer be valid. Well, what I would suggest is in that session, when it comes down to password, remember how there was blank and I put it in, you just simply have a look. It's to be held at such and such, as to be held separately. So you're going to have a separate vault or separate section where you do hold those passwords and assets, which is pretty important. Because I know you're probably like me, Brad, you forget all the time. What if the client wants a financial POA and a medical POA? So a medical POA is going to, if you're in Queensland, there's a long form. So we've got, if this was a Queensland one, you'd actually end up with a medical and also financial quite separate. And where there's different states, we're gradually going through and fixing that up as well. So is there a summary page at the end? My preference is rather than the summary page, send the whole document out Now, you don't have to send them the EPOA and the will. The preference would be send them the EPOA first and say, look, review this. You've got 3 days to come back, and then do the will. I'm going to send you the will there. Let them have a look through the whole thing, because essentially they're going to be signing off each and every page rather than just the summary. And it's a better from a legal perspective. Okay, so with the internet banking, MyGov, again, Brad and Sally, obviously the accountants of that. I would suggest, Tony, are you there at all, or?
Yep, I'm here.
So we're obviously getting a lot of questions about, Bitcoin exchanges, user passwords, banking, and all that. From a practical perspective, what do you generally recommend where people should hold all of those passwords and usernames, etc.?
Yeah, they should store them in a safe place. Well, in terms of storage, most of the wills are stored in banks from the ones that I've done, basically. So they take it to the bank and they just store it in the vault over there, the original. So if there's any passwords or anything like that, the banks or the bank basically puts it in a vault, from what I've seen. So
yeah, it's not a bad idea to have a vault, or at least somewhere safe at home in order to do that. Look, I've got from Tim, should accounts hold original client wills in their offices? I think it's best to actually have it in the client's space, because obviously if anything goes, there's an issue, it's going to be there. But, do a couple of originals, have one that's for the professional accountants can do that, or solicitors, Tony will be talking about it a little bit later on. Plus also make sure the client's got the original, just in case you have to verify that it is a original as well. So I think that's pretty important.
But we also hold the original wills here if the client wants us to. It doesn't matter. I mean, we just put it in the vault, basically.
Yeah, so feel free to use our service as well, which is pretty important. Marcello has come back and talked about the data capture form. If you're doing it by way of an interview, what I might do is, you can see that letter that we had right at the start that comes at it, that it's been prepared from the data capture. What we've got there is that, remember, that came from me ticking a box that said it has this been prepared from a data capture. What we're trying to do is put that in. And again, the same thing as that interview style is a data capture. If you haven't done it from a data capture, then you'd go no, but you want to go yes to get this protection. And again, thank you very much, Tim, for actually doing that for us. Yes, so definitely, Tony, if you got a waterproof, fire and safe, definitely I would put that in there as well. Okay, so Julie Williams, great idea. Use a digital password manager like Bitwarden. Client keeps the individual passwords, only one master password to include the will. So that's a really good idea. Thank you very much for that, Julie. So that's Bitwarden. I tried one then, and then I lost the master password, or last password got there from, and then Peter, he's using Dashlane. So it looks as though there's a few there. So thank you again for caring and sharing on that one. So that's essentially what a typical will and EPOA looks like. Hopefully you've got enough out of there and you're feeling comfortable about what we've got. It's not what it's look, we call it our basic will because it hasn't got testamentary trust, but it's not basic because you're covering digital assets, child guardianship, pet guardianship. I mean, have you seen, Tony, in all your experience, anyone that covers digital assets or the depth of what we've got here?
Never.
No.
Never.
But again, it's a simple process, really, when we have a look. I mean, because we've designed it so well, it's just a matter of effectively, going in, ticking the boxes, so on and so forth, which is pretty important. Look, I'll get, we've done the enduring powers of attorney. The successor director, in fact, are you there, Tim?
Yes, Grant, I'm here, yeah.
Okay, so do you just want to go through, because obviously you've had a lot of input into these documents, as has everyone else here, which is fantastic. But we've gone through that process of what happens on death or dementia of people who've got single director companies. So do you just want to go through what you've seen in your experience?
Yeah, do you want to, you can switch my video on if you want. I can
Absolutely. Sorry about that.
face the audience.
Yeah, well, no, you're pretty good at doing that. There we go. I'll switch Tim's video on. Let me just go through. Let me just see. So I'm going to change you to the host anyway. How's that? So you can then switch on your own video.
Okay.
And then you can flick it back to me.
No worries.
What I'll do is I'll stop sharing so we can see your beautiful face.
Here we go. Hey, Grant. Hi, everyone.
Oh, there you go. Look at that. That's what we waited for. No PowerPoint slide. We're getting the real deal now.
Okay, so what we're just talking about there, the enduring power of attorney and single director companies, I believe. Yeah, so this is what got us started thinking a little while ago, because we've got a lot of clients that, we keep separate risk in the assets. So say dad's the risky person, he's the single director of the trading companies or trustee trading companies of discretionary trusts. And mum, she's over, trustee of the company that's trustee of the family protection trust, that sort of thing. And so if dad was incapacitated, my thought always was that under a will, if someone else was able to replace them. But in discussions, Grant, with you, we realised that we actually needed something better for someone to come in and substitute as a director, some sort of basis for that to happen straight away. And so what Grant came up with, which I think is brilliant, is when you're doing the enduring powers of attorney, what we're able to do, what's able to come out with a lot of your docs is you're able to specify what companies are your clients a single director of. And then what is created is a resolution which basically says if, for whatever reason, this director is incapacitated or dies, then, this replacement director,
successor director is the
successor director. Sorry.
Yep.
So that gives you the basis for, at a future date, lodging a Form 484 with ASIC to change directors.
And I think that's pretty important because when I had a look at it, I did a lot of research, and hat tip to Dan Butler and all that, because they did a lot of research, because we did have alternate directors, which is great, and that's fine when we're doing an EPOA. But obviously, alternate as director is for someone who's you, but when you die, that alternate director drops off. So, but having a successor director is perfect in that instance. And this is just part of the EPOA kit. So that's absolutely crucial and ensures continuity. We've even gone further in that we talk about sole director, but there may be instances, for example, where you might have a sizable stake in, like, for example, a unit trust, where you might be a trustee or the board of trustees. So you still want someone to represent your interest. So it still punches out, even if it's a multi-director company. But of course, you as the advisor need to go to that multi-director company to get them to sign that resolution as a successor director, which is crucial.
I think that's brilliant, just to protect your chip on the table to make decisions. So I'm looking at this and I'm thinking straight away, but I mean, separate to wills and everything, every single one of your clients, do your company list, who's single director companies, or what companies are you in, an effective JV with by being, multiple parties in a company. And this needs to be done urgently. And we're coming up to Christmas time, I suppose apart from Victoria, everyone else is able to drive around a bit and do stuff. And but you just don't want to be in the wrong place at the wrong time. And all of a sudden, if you incapacitate a single director company, legally, you really can't do anything.
Hey, tell me, can I just ask a question, Tim?
Yeah, sure.
Let's go on the reverse side now, where there's an EPOA that's been done 10 years ago, and there's no provision in that EPOA for replacement or successive directors, and you've got the siblings fighting. What happens then?
Oh, it's a nightmare.
Absolutely crazy. I fully get, and that's why I think once you get started on this whole process, you've got the docs. This is something you need to schedule in and get updated once a year.
Yeah, definitely. And again, it's not a cost to update, because you just go in, relaunch it, and if there's any changes, just go through the whole process.
Well, I charge to update it because
Of course, I know you do. I know.
But we'll talk about that later. But that's the big. This is massive value to our clients, and we can't underestimate the value that we are creating for them. All the clients that we do great tax planning work. We might save them 10 grand in tax. We do great work in other areas. We might save them here and there. The work we're doing here is potentially protecting millions of dollars.
Correct.
And accountants, I think, from what I've seen, need to appreciate that. I mean, it's absolutely brilliant what we're able to do. So it's getting, and the document I've got later on, which I'll share. Just
do you want to go through, maybe while we're doing that, it's a good segue for you to start sharing now that while you've got the hosting.
Okay, I'm just going to open up that document.
As you can see, we've got a really basic data capture, which is good, and try to encompass everything. But I know certainly change and Tim's stuff is even stronger still, because that's their focus.
So this is, I'm going to share my screen and just blow this up, and then
don't blow it up literally. That's the last thing we need.
No, I did that. Okay, just jump back on here and share my screen too.
Actually, Tony, while you're there, you still there?
Yep.
Matthew's actually asked a good question. Matthew Burke, what happens if someone actually goes missing? What's the legal process of that?
Who goes missing?
So we got missing. When do you, obviously it's not incapacitated. Look, a successor director should be fine as missing. But what normally happens, that it takes a while before well, obviously it's not going to be dead, but what would happen there?
Oh, well, there's got to be, like anything else, I guess, there's got to be an formal investigation by the police or whatever it is. And then from there, they ascertain basically,
Take it from there.
maybe dead. Who knows what's happened to this guy, or whatever, I mean, but there's just got to be a formal investigation. And if he's found to be dead at the end of the day, well, then it's got to go through the coroner and all that type of stuff. And once that's all finalised, that's when you can exercise that power under the EPOA, I guess.
Well, you should know. I mean, Dan Andrews has been going missing for all this year anyway.
Well,
anyway, go on.
Don't get me onto that. No, anyway.
Hey, Grant, can you see the Word document there?
Yeah, definitely. Maybe just take it up a little bit bigger so we can.
Okay.
That's it. Yeah.
How's that? Okay.
Yeah, that's good. Yeah, I'm on it.
So, as everyone knows, with what we're doing with Change GPS, apart from having great documents and work papers and things like that, and apps that create advice, a big push behind everything we do is helping our clients to really value and love us as accountants and advisors what we do. And it really annoys me that we don't get sometimes the appreciation from our clients for the really good things that we are doing. So we're trying to make it easier for accountants to do that. Accountants have been trained, are good with numbers, but haven't been trained with words and writing. So we all acknowledge that. GPS is here to make you look great. So what I've put together here is actually based on when Grant started doing all the light year docs and the leading member documents. It blew me away. It made so much sense. Like, why would you leave anything in the estate when you can actually have all the value out in the exact areas where you want, which are protected, are tax effective, and will be kept in your family bloodline. So I listened to every webinar and re-listened to it over about 6 months. And I think Lyndall kept coming in the room and said, "Is that Grant Abbott always on?" I said, "I'm just listening to his webinars. It's fine. I'm just listening to the recording." So, Grant, she knows your voice very well now. And what I was doing was in getting it in my mind, how to explain this to a client. And for Change GPS members, you can get this today. If you email us info@changegps.com.au and say, "Hey, Tim, I want the asset protection estate planning doc," I'll send this to you. Now, this will be an app next year. We're going to expand this out. We're going to get Grant's input. I'd love it to kind of have an app that creates that, push a button, goes through the light year, push a button, goes to BGL. That's the sort of thing that we like to do. So this letter that you're about to see has everything, goes to about 24, 25 pages. And the app will actually shrink it down. So if you've just got a basic will for mum and dad, or a basic power of attorney, or advanced health directive, or if you want to go into protectors or PPSRs and that sort of thing, we'll go into all of that as well. Okay, so let's have a quick look through it. Protecting your family wealth. By the way, we're going to add in a letter of wishes content as well. And I've got to talk with Grant about how to kind of merge that through in the whole system here. So a bit of an opening line about protecting your family wealth. And also saying, look, if you've got future business transactions, you're going to need to seek advice from us. So if a client changes anything, we need to relook at this. We go through the client's objectives and concerns. Now, again, you can add or take anything you want from this letter. Don't get hung up on the wording. The wording works fantastically. This is what I've used to have about 20 odd protectors and estate plans in the last 2.5 months with clients. And I'm tweaking it all the time, but you might find that you want to remove something or take something out. But we start off with what the client's wants and needs are. What I then do is, for business clients, I go into what is asset protection, because a lot of clients don't understand asset protection. In fact, a lot of accountants don't. So we go through and explain asset protection is isolating assets or value from risk, segmenting multiple sources of risk, limiting the assets held by at-risk individuals. We then go through the 5 principles of asset protection. And anyone that's been part of Change GPS, I've done multiple webinars on this, so you understand that. Separate the risk from the assets. Choose a risk taker and an asset holder. Separate business risk from business assets. So you might have a trading entity, but we want to have a separate entity for the assets for that trading entity. Different businesses should operate from separate entities. We see a lot of this when we take over new clients, multiple businesses from the same, run from the same entity, which is just crazy. And accountants don't offer to their clients to actually set up another entity because they're thinking, oh no, I'm going to, I don't want to offer it to my client because the client doesn't want to pay. Wrong, your client does want to pay. You just haven't explained the advice and the value behind your advice. And last one, which is a key one as well, I've lost track of the number of clients we've taken on board where you've got a company with $1 million in retained profits or more. Move the surplus risk from the asset company, so from the risky company across the asset company. And those that are using our structured advice document in Change CPS, we've got a diagram which explains that. So it's really important to do. Just a quick question, Steve, this isn't on Change GPS yet, but because I'm tweaking it, but for everyone here today, I'll send you a copy of it and you can start using it. This will form the basis for an app. So that way we can keep updating it, tweaking all the time, and you've always got the latest content. Okay, so key considerations then about asset protection. We run through what we're trying to achieve. And then this is where we start to tweak it. So within a family group, we say, look, who's going to be the risk taker and who's going to be the asset holder? And sometimes if the kids are involved, you'll have more people. Sometimes, for example, we've got like 2 doctors that come in. They're both risk takers. There's no asset holder in the family. So we have to acknowledge that and tweak the structure slightly. And now this is straight from what Grant's been explaining. So we look at estate planning, a smarter approach. So it's kind of dignifying. A client might have done something in the past. We don't want to say you're an idiot. We don't want to say you got wrong advice. We just want to explain, look, here's a smarter approach to doing things. And so we're trying to do it with using multiple, multiple pictures and things like that. Just to say, look, in the past, everything goes in this pot called the estate for the beneficiaries. And as Grant explained, Problems of Family Provision Act and other lawyers. And here we go, we've got the devil in there. People can attack that estate, the judges are in there as well. So look, what's a smarter approach? Transfer your equity and assets under your control to a family protection trust. Establish an SMSF will with an SMSF death benefits trust. Have minimum assets in the estate that an aggrieved family member can fight over. So you can see the language is really straightforward and simple. Okay, so this is the smarter approach. Gift your equity to a family protection trust in properties or in businesses. Now we're valuing businesses and we're actually, it might have bought a business for $500,000, now valued at 5, we've got a value uplift of 4.5, we're gifting that equity across. There's no CGT trigger, no stamp duty or anything like that. But we're getting the effective value across in a family protection trust where beneficiaries are effectively hardwired in. super, direct that to an SMSF benefits trust. And what's in the state? Almost nothing. So there's not much to fight over there. So to me, that when you show a client that diagram, they really get that. Grant, what are your thoughts on that?
Yeah, look, I think that's great. Just interesting because a lot of this stuff that I find is because you got the big keywords. Because when you talk to clients, clients have to generalize because there's so much information we get these days.
Yeah.
So you have to hit those hot words. So to me, one of the hot words, and I'm sure you've seen it a long time, is that idea of bloodline. We're building a bloodline SMSF or one that's going to protect your wealth for your bloodline only. And particularly in these days of, children and all that having multiple relationships, it seems to me, well, I know that it's a really good idea.
Yeah, and look, there's a firm up here that trademarked the term bloodline, and
I don't know how they did
we
that.
had a little skirmish with them 2 years ago, and suffice to say, they didn't win. The important thing to say is that we're here to help to keep your wealth in your family bloodline.
Yeah, and that's why we use the word leading member, which to me is a better structure because
100%.
we can apply it across everything rather than bloodlines too ephemeral. But if you say leading member gives succession, asset protection, and also bloodline protection, that's really the key.
Much better. And so to do that, again, we've made it so easy for you. We've explained the whole leading member concept here. So they're all Grant's words put together in a GPS style there, which helps clients to understand it. So David, thanks for your feedback. I think it's fantastic as well, this letter. We have initial discussion, and then this is to consolidate the engagement. So you would have seen, and we're expanding out, we've got a marketing system and change GPS. We've got education, confirmation, and decision. So this is a blend of the confirmation and the decision sides, helping clients to understand what they need to do and the decision they need to make and the price. So I'll come to prices in this as well. This document's got everything you need. Once you've had the chat, this explains everything and engages your client. So we talk about the leading member, then we talk about how to select the leading member. And then we go, right, here's the leading member, here's the first successor, here's the second successor. Then these are the 4 leading member structures that Grant talks about. So we go through and we briefly explain each one of these, okay? So I won't go through that in detail, but we've got all the content there which explains it. Now, when I have a meeting with the client, by the way, I just get them online on Zoom or have a coffee with them if you can, and just read through the document. You spend an hour, you read through the document and answer any questions that the client has. It's simple. Just read through it line by line, and they just talk about it. So we go through SMSF will, executorship. So we look about, okay, based on discussions, here are the people that can be executors and successor executors. Then we go through the EPOA, and again, it probably mimics the executors. And here's where we go through sole director companies, alternate director. I think successor director, I've got to update that to now, Grant, isn't it? Because that's the word we're using in the resolutions.
Yeah, successor director.
Yep. So I'll update that. But it's the same sort of thing. So we'll list out all the companies. What we're trying to do is show your clients the value of what you're doing and just how much work there is. Now, it's done quickly on Grant's system, but that doesn't mean that you just charge an hourly rate. We're looking at value pricing here. And I don't tell a client I can do this in a limited period of time. Like, this is high level knowledge that not many people understand and is so valuable to our clients. So don't undersell it. It's like the person doing brain surgery. Do you go to the cheap person or do you go to the best person? And you'll pay the best amount for the best person. And, this is what your clients need. Their wealth and where it goes is so important. So we go through advanced healthcare directives. So everything's there. And then, comprehensive estate planning, the MOAT. It should include all of these things. Now, some clients might want it. Some clients might have SMSFs. So you pull that out. No dramas. You adjust this according to what you need. The app will do that automatically. So I've got all the logic I'm working on the app. It'll blow your mind. It's going to come out next year. I don't know when, early part of the year. It'll just make it easy for you to do this advice in less than 5 minutes to your clients. We then go through the protector. And so for those that haven't used the protector in the past, we've got everything there talking about clawback periods, voidable transactions, undervalued transactions. And look, I'm not a lawyer, but again, if you do this when clients are in a solvent position, and one of the documents that Grant and Tony have put together is a solvency document which the accountant signs off on. If everything's done in the right way without an intention to defeat an existing creditor, I've not seen any cases ever, and I can't see any logic behind the court saying, oh, you can go back and overturn this. If you do it when you're solvent, some people say, oh, you've got this 4-year period and they can be overturned. That's when there's, and I think, Grant, you'd have to say, that's when there's outright fraud or outright trying to avoid paying someone. If you do this now and someone sues you in 12 months' time, how can they say that you did this to avoid this person 12 months' time?
It's exactly the same in the Bankruptcy Act in making a contribution to super. You actually have to prove that you've defrauded, you're seeking to defraud or intend to defraud the creditors. So if you're solvent, then it's a big issue. And we'll know that when it comes down, I think that's the important feature out of the Protector, is the first document that comes out is the accountant's solvency certificate. That's why it's in there. It's an absolutely crucial one.
Yeah, 100%.
100%.
Oh, Tony, you go, mate.
No, 100%. I agree. That's the way it is.
Yeah.
And look, it's really important to understand this, because I hear so many accountants all the time, they get spooked by their friendly neighbourhood suburban lawyer. Says, oh, you can't do that. It's going to be clawed back. It's these things don't hold up in court. But you know what? I've never seen any facts to disprove this. I seriously have not seen any facts at all. It's just hearsay, and then accountants are too scared to do anything. And so they move into this position of fear to help their clients, rather than being on a web event like this today and learning this really high level content. This is what your clients want. Your clients want you to be on the front foot. I would so much rather be doing this and be on the front foot. And then if some lawyer wants to have a crack in 2 years' time, be my guest. You prove that we were trying to avoid paying something 2 years ago when that something didn't exist.
I think it's also pretty important if you have a look at the Adia versus Nussbaum, and also Perry and Nolan, which is a family law case around this, is the documentation is the be all and end all. And, once it's in the trust, then they actually have to prove that it's been, fraudulent. And again, whether that is, it depends on how much money the trustee in bankruptcy has, if that's going to be the case. But at the end of the day, isn't it better to do it and try it rather than not do it at all?
100%. So look, just get in there and start doing it. Sorry, Tony.
No, I just want to add, the client at the end of the day is paying you as an advisor to find a solution to his problem, mate, at the end of the day. That's what he's paying you for, right?
Exactly.
He's not paying you for to cut slabs out of legislation and say you can't do it. Everything's doable at the end of the day, to an extent, right?
Yeah. Oh, look, that pisses me off, is I see so many letters of advice from some leading stalwarts in the industry, and you go down and have a look, and they always say no, or this is not this, and they put all these disclaimers, and that's something that we never do at Abbott Mourly. I mean, there's either a solution, or if there's not a solution, we'll simply say, look, it's not possible, or it's got like only a 5% chance of success. But if it's 50-50, then you just work it around. And look, I think this is great. We're getting some great feedback on this, Tim, from this letter. For everyone's going to love it.
Oh, yeah. Well, look, you're going to love the letter, but I tell you what, the app is going to blow everyone's mind. It's just going to, and as Michael said, we'll link it. We want to link it to Lightyear Docs too. We want to make it seamless. Bang, bang, bang. We'll do the front end. We'll help with the engagement part. We'll focus and tweak that, while Grant and Tony and Michael and the team just keep tweaking these, the documents and pumping out. It's kind of a two-part process there. So after the clawback, then we go through how the Protector works with properties. And this is beautiful. 3 steps: establish a family protection trust, gift your net equity to the family protection trust, and then immediate loan back with security. So we have done this a number of times. As I said, I've done, there's about 20 I've done. There's 11 or 12 that we've done it with security. The remaining 8 I've got to send down to get the second mortgages put on them. And it just explains to the client. Now, you would just tweak this according to the values for your client. Now, again, the app will do that. And the app will actually be a starting point for a much bigger app. So part of this process will be, okay, who's mum, who's dad, what do they do? Who's the risk taker? Who's the asset Then we'll look at what assets do they have, what names are they in, which companies of trust do you have, who are the shareholders, who are the directors. And behind the scenes, I'm not going to use the word AI because it's not, but it's going to be the starting point. It's going to use logic to basically come up to you, first of all, with like an error kind of thing. Hey, this asset person is a director of a trading company. This person is this. So it'll come up to you with what you actually need to do. And then you can give this advice to the client. And it will have all the amounts and data in there. And this will lead into wealth apps that we're going to be creating, because this is the starting point. But you imagine if you pushed a button, now you've got your assets and liabilities in there, and created an entire rest of your client's life, wealth and cash flow and tax document. And then what if you just were able to push a button and run a scenario to, let's put all surplus cash into super, or let's put all surplus cash in investment property. Now, it's not financial planning advice, it's purely cash flow and tax modelling.
So I think that we had a question before, which was a really good question. There's obviously a lot of people on the call, is they've both got accounting and planning. Where do you put all this through? I would have put it through the accounting division.
100% the accounting division, yeah. Whatever deal, unless you're self-licensed, like the dealer groups, they would like, you know, they always say in your SOAs, you need to get your wills done, you need to get powers of attorney done, blah, blah, blah. But no one ever does it. So very few have, you know, and they never follow through. So we would, in it with our financial planning, so we're with Lifespan for financial planning. They're fantastic. We've recently moved to them, blown away by how good Lifespan are. So a big play for Lifespan. We make those recommendations, but we always just go, this is all done via our accounting business, 100%. Now, the letter going back to it, we then go through, and this is the key here, we're going to work with our preferred estate planning aspect lawyers, Abbott Mourly, to have these documents prepared for you. So this is the key, really important to remind your clients, you're not preparing these documents. We're working with our lawyers to have these prepared for you. And the recently Change GPS member responded to a Facebook post in WA saying, hey, someone said, can you help me with, I need some help with...
I love that one. That was
this is a great war story for everyone, you know, because we went in battle mode and we won again. We're not trying to be, you know, egotistical here, but just to prove the point. This GPS member responded to a Facebook post. Someone said, I need some assistance preparing or getting wills done. And she said, look, yes, we can provide assistance with that. Here are details, contact us. And some annoyed lawyer contacted the WA Law Society. And so this member got a letter from the WA Law Society basically accusing her of providing legal services and blah, 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 all this stuff. So Grant and Tony put some content together to myself, which we sent back. And she basically responded, well, number one, I'm not providing legal services. 2, I've never provided legal services. 3, I've never charged for providing legal services. Number 4, my comments in relation to yes, I can provide assistance are 100% true. I use Abbott Mourly lawyers that are doing this. I provide assistance by way of doing that. There's no problem. And she got the letter back yesterday. Okay, we get that. Nothing to see here. Sorry. Exactly. Yeah. So there's another example. Like, you accountants, you're allowed to say, I'm assisting. You're not saying I will prepare the will. Abbott Mourly prepare the will. You data entry. Okay. So this confirms it here. And then we talk about this is what we need to set up for you. This is what we need to do. A few other things to consider here. Okay. So you can put in whatever else you want there. And we can say, look, if you want additional advice about clawbacks, limitation liabilities, you know, and this is kind of like if a client wants to get into more nitty-gritty and pay for it, by all means. So you've offered this additional help, but no client ever wants that because they're happy with the rest of this. Then we go through how the protector works with non-property assets. I love this because we can protect working capital loans with PPSR situations. And again, we go through here. So there's a lender. So say we've got a few scenarios, and I know, Grant, I think you're working up a slightly tweaked option to the promissory note that we did recently for a client. Yeah, but if you've got a client that is about to lend money, fantastic. You do a loan agreement now, and then you secure it. But if they've done that, loaned the money in the past, how do you protect that loan? Well, you can issue a promissory note, take a mortgage deed, and then PPSR registration. And again, that is fantastic. If you've got a client that wants to declare a dividend out from a trading entity to a holding company, but they don't want to pay the money out because of it's tied up in working capital, declare the dividends, not paid yet, have a promissory note, cover it all off. So we've got all the content there to go through and explain that, which is super cool. And you can tweak that. And then this is the part that we'll love as accountants, the prices and stuff. So we go through, we look at our recommendations, like here are the assets, what's the strategy, and who's going to get it. You see, this makes beautiful sense. We could put in life insurance policies, remaining assets. So that's the content there that'll be in the estate. Hopefully life insurance might be through an SMSF, through to an SMSF, a death benefits trust. You can gift your household furniture items, whatever, jewelry to a family protection trust. So that's all the key value in there. And then here's the value of our advice. While no one can give you a 100% guarantee about asset protection, the strategies we've recommended to you will maximise the probability that net equity in your home, invest properties and other chosen assets of more than X amount million will be protected. And remember, even if you've got a client that's just got a couple $100,000 worth of equity, they might have $1 million worth of life cover. When you add things up, most estates are 1 to 1.5 plus, and that's for your basic mums and dads by the time you factor in life cover. So, I mean, it's big stuff. And here are the prices. Leading member discretionary trust, we've actually made that 3.5 plus GST now as ASIC put the fees up a bit. Protector, 5 plus GST, deed of gifts, so put whatever prices you want. We use these prices and they work. Just an important note, if you gift assets to a family protection trust, you need to arrange new insurance policies. Then here are recommendations. Upgrade constitution to leading member constitution. Upgrade to leading member trust deeds. Upgrade this. Next steps. Review this. Let's have a Zoom meeting. Let's get this started. Do you like that, everyone?
Love it.
That's awesome. It's great.
Awesome.
I think. Are you there, Mick? You might be off there. Yeah. What do you think? Obviously, you've got a thriving practice. I mean, you will come and have a chat with you a bit later on that solvency stuff with someone who's really down the turkey. But what do you think about it all?
I think it's wonderful, absolutely brilliant. I can't turn my video on, but yeah, it's amazing, Tim. Very, very impressed.
Thanks.
And obviously, Grant was talking about me coming in later and talking about solvency and pre-insolvency and everything, which is sort of after the fact. I like how proactive this is and getting in front of your clients and providing such a great value-added service to them. And it excites me even more as we look towards Light Year Docs 2.0 and working with Change GPS and the move, I guess, to ourselves to be an application-based portal as well. So, and once there, that two-way communication starts happening, and we've got our strategy, what we're going to call strategy bots and strategy widgets, and our events-based reporting that will ensure that you're doing those regular reviews through this process. It's going to be fantastic.
Where are we at, just while you're on there, where are we at sort of up to with the, I know you've been pretty heavily involved in that whole process with Light Year Docs too. Where are we at the moment? We
engaged an external independent partner by the name of Doc Govern, who is run by an ex-Hot Docs executive, and we're almost to the point where they're about to deliver their final report. We've nailed it down to about 5 different providers, and we're just looking because what we're moving, I guess, for use of a better term, I think we're probably moving to what I would say we're like an e-commerce site providing documents, legal and business documents, to, as Tim was pointing out in terms of Change GPS, to an application that will look very much like you're working within a BGL or an X0 environment, and we're going to have extremely flexible integrations between Xero XPM, Change GPS, BGL, Class, and any other databases that people use. And it'll basically be an application that you log into on a daily basis. You'll be able to create your documents, but we'll have, as I mentioned, a strategy bot that will, I guess, try and bottle up all of Grant's amazing knowledge and around documentation and strategies, as well as the rest of our team. and our members, and provide solutions to everyone that link into our documents and then link into those systems.
Yeah, look, I think from what I've seen and exactly where we are now with this older technology and how we've managed to build it, and we'll go into the moat after the next break. But with us, with Change GPS and Tim, it's quite an amazing. Really, there's so much there that's done for you, letters, emails, all that. So it's almost, and you'll see how easy the documentation is to do, really sophisticated, is that you can run a really lean and mean back end without that much. So the idea of having to have lots of juniors go and build all this stuff or liaise with lawyers, it's basically, I know you've done a lot of stuff, Mick, around this, but you virtually can do these things in there really quickly.
Correct. Yeah. And Tim's got on the screen there his application there, and so obviously we'll have two-way feed going into that, which will be great. So when people are setting up companies, or if they want to set up a company, or it's part of Tim's strategy paper that comes out, they can link straight in and set up through Lightyear Docs 2.0.
That'd be great. So you just want to explain what you've got there, Tim?
Yeah, so this is Blueprint version 2. This reads from either Xero Practice Manager or BGL CAS. Reads all the relationship data. And so this is $100 a month, which is, for small firms up to 15 users, which is next to nothing. But it just means you can instantly get a very quick diagram. So we'll just export that. Fantastic. We'll print preview it, print it to, just open this up here now. So that's what you can have for your clients. It's got all the structure details underneath and the diagram at the top, which is just, I think, brilliant. And just to get that through instantly, for example, this is just reading it. I'm just going to load this up, load all of these. This is reading straight from XPM. Bang, it's all there. Brilliant. You can drag and drop that around, change it around, do whatever you want. Yeah. So it just takes your data and makes super quick use of it, which is great. And I've got some massive structure charge 50, 60 entities on it, and it just makes it so quick and easy. That's all about using your data. And that's what I want to work with Grant and Michael, to be able to take your data from XPM or BGL CAS, do this so your client can understand it, explain the risk and the assets. I think we've got the toggle snap here. We've got a risk and asset overlay, which we can kind of put over the top of this and then explain, what are the differences, and then I use that with the clients. It's just fantastic.
And I think it's great having, I guess it's that link into, say, Xero XPM that provides you efficiency savings by having the ability to access your data, but also having that one source of truth to pull in when you're setting up structure diagrams or you're creating new documents and everything. Obviously, a lot of ours now we go through and type them in, but to be able to pull that information, which we'll have very soon. Our intended launch date is April, and I believe we should be able to stick to that. So
fantastic. So yeah, you can just add whatever entities you want by drag and drop, put relationships, do whatever you want. It's just super quick. So
a couple of things that I just got from a question from Julie, who's we're picking up quite a lot of business now from financial planners who see that this is not necessarily the trust, but some of the structuring. They're seeing this as a new world. And I think when we get to the old associations of pepper and we do get that specialist, it's going to open up a brand new world. But currently, what do you suggest around financial planners who aren't accountants around Change GPS?
Well, look, it depends what software you're using. For financial planners, we're going to have a wealth app next year. And so the app that we launch with the estate planning is the start of that, and it will grow from there. So I'm pretty excited we're not going to do statements of advice or things like that, but we're going to do everything for accountants to be able to help explain wealth to clients, almost like quarterly reviews of assets and liabilities and performance. Now, planners will be able to use that. So I'm frustrated because there's no, you look at Xplan, Midwit, all the others, there's no software which properly looks at how your assets, investment and business and everything else are growing over time. Clients want to know that their portfolios, their overall, investments portfolio is growing. And so what we'll do is create something that accountants can maintain that relationship, give quarterly or annual updates to clients, give estate planning risk updates. do their asset protection, a whole range of things. So Julie, we'll have something next year for you, probably towards the middle of the year. Sorry we can't work any sooner. We've just got so many things on our list that we're slowly ticking off. The other thing we're working on is just some updates to Tax Plan Plus right now. So GPS members, we want to have the tax flow report, which is kind of the cash flow of the tax. That's going to be out early in the new year. Sorry, it's taking longer. We've had to build Xero's version 3 of their security upgrade first of all. So that was just kind of pushed on us. We had to push all our dev back.
We've got a question from Mrs. Sally Rourke. She's saying, Tim, if you're incorporating a new SMSF into the strategy and need to provide an SOA, how to explain and delineate the advice under AFSL versus tax advice?
Yeah, look, that's a really good one. Again, accountants are allowed to talk about certain things, and you'll be the best person to explain that. Accountants are allowed to talk about the tax effects of strategy. There is nothing that stops. So I would be, if I'm talking about, like if you're going to recommend a self-managed fund, number one, like accountants can't, but as you said, Grant, you guys can recommend that and set that up if a client wants it. So it's a client self-directed thing via you guys. And I've had clients ring up and say, look, Tim, I want to buy this commercial property. And our dealer groups in the past have said, even if a client self-directs, you still got to do the full fact find, you still got to do the statement of advice, blah, blah, blah. And it's a joke because a client is smart enough to understand, like I had the CEO of a massive listed public company. He's one of my clients, and he wants to buy property in an SMSF. He knows backwards. He's dealing with
Property,
investment people every day of the week. He knows what's going on. And our dealer group said, no, you got to do a fact find, you got to give a statement of advice. And it's just embarrassing to charge, $2,000 to do that for a guy that's very knowledgeable, very smart, knows what he wants. But this is what ASIC says for his protection. So
crazy,
it is just ridiculous. So, and for CSEs are differently. It's crazy. So what I'd be doing is, from a tax point of view, I'd be saying to a client, okay, you need to get advice. Like, we're licensed financial planners, so we can give them that advice. But I'd be first of all just giving them a diagram. Okay, yep, self-managed fund, drag that up, put that in there, fantastic. Explain how it would work, but saying, look, this is not advice to actually do them. This is advice on the tax consequences of using super, whichever bucket you use, whether it's a retail fund or whether it's a self-managed fund. Now, whether a self-managed fund is appropriate, that comes down to your ability to give that advice, comes down to what your dealer group tells you.
And also, I think it's, as I said before, that Tony Tony, are you there, Tony?
Yep.
Yeah, where you've done quite an extensive letter of advice and also discussions you've had with clients where we can do the startup, the establishment, discuss it with clients, the establishment of the SMSF up front, because obviously, as from the legal side, you're not bound by the Corps Act.
No, not at all. We've had many clients come to me basically saying we want a self-managed super fund. I take them through a first Zoom. I ask them why they want the super fund for. I take them through a series of questions at the end of the day. And then we can proceed basically in terms of setting up their fund. But obviously I've got no capacity to establish the special purpose company from my end. So what usually happens is I instruct the accountant actually to set up the special purpose entity. And then once that's done, comes back to me with all the directors' names, shareholders, etc. And then I set up basically the SMSF trust deed with a real pretty detailed letter of advice. I think it's about 10 pages basically,
Yeah, it covers a lot of questions that, for those of you who established SMSFs recently, you probably find that your ABNTFN can blow out to almost 4 to 6 weeks. Now, because with COVID, Commissioner is obviously very concerned about early access to super, and 70% of clients are setting up, will get a phone call from the Commissioner, which Tony takes them through some of the issues that will be raised on those calls.
Yeah, so it's pretty straightforward, but when you, because I know how not difficult, people get a little bit nervous once they get, once the ATO starts ringing up, they get a little bit nervous. So I take them through basically a series of questions in order for them to get some level of comfort.
It's like massaging their testimony.
Massaging them a little bit, you know.
We've got a list of the questions that the ATO asked, because this happened to a number of our, and the ATO try to keep it secret. But I'll send it through the Grant and get out to everyone. So if you've got a client that wants to set up an SMSF or whatever, just give them these questions, say the ATO will ring, and let's just make certain that you can answer them.
Fantastic.
Yeah,
I might, what we might do now is we've been going for a pretty good slog. What I'll do is we might start back at 11 a.m. Let's have a break, toilet break. 11 a.m. for Brisbane time and 12 o'clock for Australia. 11:30 in Adelaide, and Western Australia would be. Graham's going to tell me on that one.
Can I just add something before we go for a break?
Yep.
Guys? I'm just saying this because I've heard a lot about the documentation and as to why the documentation is set at a price at $99. Make no mistake, right? Because our prices are at $99. Make no mistake that these documents are pretty well vetted and they're excellently drafted. Okay.
Yeah, exactly. So it's the technology. As the technology just shows that there's a lot of people, a lot of lawyers out there who I saw the other day. Top Docs is going to give you free ancillary docs, but you have to upgrade your client. This is just SMSFs. Upgrade the client deed. It's cost $384, and then it's $99 a fund per annum, which is like crazy. If you've got 100 funds, you're just going to be slogging them a whole lot of money for virtually next to nothing. But look, anyway, let's have a break. I might get you to flip me back as a host there, Tim, and we'll see you guys back in 5 minutes.